2, Tesla and another against Interdigital Patent Holdings and others.
Yep, Mr.
My Lord. My Lords, yesterday I was explaining to your Lordships why care has to be taken before assuming that my client's licence must be subject to review by the courts. I'm about to make that good on the law, but I just wanted to finish my overview by briefly addressing some of the interveners' submissions. Now, for the most part, the interveners seek to support Tesla's case by petitioning this court on the basis that the existing ETSI provisions and those of other standard-setting organisations whose systems are not before this court are not fit for purpose, so the court must intervene. Now, with respect to the interveners, such cries do not add materially to what Tesla is already saying. And insofar as they allegedly constitute more evidence, they are woefully lacking in particulars. And for Avanci, we note Interdigital's written submissions on this point, which are in the supplemental bundle, STB, page 3. There are, however, two specific points made by the interveners that I would like to address. The first is that I commend to your careful consideration the submissions from the International Centre for Law and Economics, which are in the key bundle at page 174. The ICLE presents a well-referenced economic analysis explaining at least three important points. The first is the economic and commercial benefits of platforms of the Avanci type. That's particularly around their paragraph 4.2 on page 179. The second point is how such platforms properly coexist alongside the SEP holder's obligation to grant bilateral licenses, such that they do not require separate court supervision, because the bilateral licenses keep them in balance. And that's dealt with especially at paragraph 6.3 on page 184. And the third point is how excessive regulatory interference with such platforms can negatively affect their benefits, negatively affect their proper operation in a free market, can actually risk platforms collapsing, and can certainly discourage new platforms being formed. And the ICLE picks that up around their paragraph 7.5 on page 187. And we respectfully submit that these are well-considered and powerful submissions which are consistent with Avanci's legal analysis and which as a whole counterbalance the largely unfounded assertions that the platform licensing is something which this court must somehow find a way to supervise and regulate. The second point I wanted to pick up from the interveners is to expressly draw your Lordship's attention to the submissions from the Motion Picture Association, which are in the key bundle at page 229 from paragraph 27. In this section, the MPA is picking up a point from Lord Justice Arnold at paragraph 21 of his judgment in the Court of Appeal. That, for your note, is on page 241. And that is that Avanci is similar in some ways to the collective management organisations, or CMOs, that exist in the field of copyright. The CMOs enable businesses, universities and the like to easily obtain licenses to copy parts of books or newspapers and so on. The idea is that the university or business pays a pre-agreed licence fee, and the CMO distributes the collected fees amongst the large number of copyright holders whom they represent. And the point which Lord Justice Arnold and the MPA are seeking to make is that such schemes are subject to review and regulation by the courts, most notably in the United Kingdom in the form of the Copyright Tribunal. And the suggestion is that because these CMO schemes are subject to the courts, why not SEP collecting societies such as Avanci? And the short answer is that Parliament has expressly made legislative provisions for the regulation of CMOs, including the creation of the Copyright Tribunal, all of which are set out in the Copyright Designs and Patents Act 1988. And in contrast, Parliament has not, at least yet, decided whether to do the same thing in respect of SEP licensing. As the MPA points out, and as my learned friend Mr. Alexander mentioned yesterday, there is widespread and ongoing consultation and debate, both in the United Kingdom and in Europe, as to how to deal with SEP licensing. The Fair Standards Alliance, one of the other interveners, in their submissions at Key Bundle, page 211, in footnote 15, refers to the European Commission's proposed SEP regulation to improve the regulatory framework around FRAND licensing, albeit that consultation or proposal has been withdrawn by the Commission, causing much international controversy. And at Key Tab 8, page 194, another intervener, the ACT, refers to the UK government's recent consultation on SEP licensing, which includes proposals for establishing, for example, a special litigation track for SEP disputes. Now, as I said yesterday, everyone recognises the importance of SEP licensing and the need for efficient solutions, but it is all under consideration by the various legislatures, and no scheme has yet been set up. Now, whether it's appropriate for the United Kingdom, Europe, or even internationally to take such a course, and if so, what course, must, as in the case of copyright, be a matter for the various legislatures. And with respect to this court, it is not for a domestic court to unilaterally create a supervisory jurisdiction if, as my client contends, no such jurisdiction presently exists. And that's no matter how desirable Tesla or the domestic court itself might think such a system would be. And we respectfully say this is especially so in circumstances where, in the present case, the relevant markets are international, and very substantial scrutiny of whatever this court does will be exercised by businesses and courts throughout the world. As the court will appreciate, very great care was taken by this court in particular, but also below, with the unwired planet jurisdiction, to do only what was already within the scope of the SEP holders' contractual obligations to Etsy, and without stepping on the toes of foreign courts. But even then, I'm afraid criticism is already being raised by courts across the world as to the way in which the United Kingdom's courts have been addressing FRAND and SEP-related disputes, including the unwired planet jurisdiction itself.
May I ask where that is?
Why that is?
No, where it is. Where can we see the extent of that concern about the approach taken by the UK courts hitherto?
Your Lordship will see it in various academic. We don't have very much in terms of papers before this court. One will see it most recently, I think, in the Amazon litigation, where there has been disputes between the Unified Patents Court and the German court, to the extent that where this court has, for example, tried to grant interim licenses to prevent infringement proceedings taking place in Germany, Germany has said they won't recognise those interim licenses, and have even gone so far as to hint that even where the court sets a court-determined licence, if that hasn't been consented to by both of the parties, because it has been forced on the SEP holder, the German courts have indicated that they may be reluctant to recognise the licence as a defence in infringement proceedings, because it doesn't have the consent, which is the necessary part. So the necessary requirement on infringement. So one can look at virtually every foreign court decision which has had submissions made to it about what's going on in the United Kingdom, and putting it at a low threshold, one doesn't find a universal acceptance of what the United Kingdom is doing. Does that assist, my Lord?
But none of that is before us.
I think you will find hints of it in the various authorities, particularly the Amazon authorities, but the majority of it isn't before the court in the papers.
Thank you.
As the court will appreciate, the question for this court is not, does this court think it would be a good idea for the courts of England and Wales to be able to scrutinise platform licences, but rather, do the courts of England and Wales already have such a jurisdiction? And we respectfully say they do not. Just before I move on to ground one, I want to pick up a point which my Lord Briggs made yesterday about the inability of a specialised sports car manufacturer to go around agreeing 100 or so bilateral licences for a few dozen cars each year. We completely agree, and such a producer really benefits from a platform licence such as Avance's. Now, as positive, though, we would venture to suggest that such a small entity would never be able, or even desirous, of challenging a platform licence, even if it had the power to do so. That doesn't mean that others like Tesla might not be able to challenge bilateral licences. Your Lordship's scenario needs to take into account the existences of big companies, not only Tesla, but Ford, BMW, Volvo, and the like, who are very able to determine whether the platform licence is a good business deal compared to bilateral licences. If it is not, the platform isn't going to survive on just a few tiny specialist producers. The big entities who are able to contemplate and evaluate the next best alternative, which is bilateral licensing, act to keep the platform price within reasonable bounds. And that's precisely the point which is explained from an economic perspective by the ICLE in paragraph 6.3 of their intervention on page 184. They say it's the platform being disciplined by the competitive constraints of independent licensing. The power of such big entities acts so as to keep the universal platform rates fair for everyone, especially the small entities who could never challenge the platform even if they had the right, could never in fact challenge bilateral rates, and who would indeed struggle even to negotiate bilateral licenses. 100 licenses at the Avance platform rate of $32 is only £3,200. That wouldn't pay the salary of a member of staff just to write letters about bilateral licenses to all the SEP holders. More generally, my Lord's small car company can be thought of as representative of many of the SMEs referred to generally and across the various standards by the interveners, who find themselves needing rafts of technology licenses but have little ability to negotiate or challenge on the small values and the small quantities of their products. Platform licenses, like those of my client, give them ready access to the standards at non-discriminatory rates, and the control of the fair and reasonableness of the pricing is affected by the big beasts who are able to contemplate the next best alternative. Is it better than bilateral licensing? Now that brings me firmly to ground.
Can I just ask? I mean,
yes, my Lord.
Your case is that you have a preference in sort of policy terms for a free market analysis
yes.
of the terms of a global license. As against that, there is the argument that these licenses should be FRAND. Now, what is your objection to the licenses, albeit global, being insisted to be FRAND?
My Lord, the problem with saying that they're FRAND and bringing them within the FRAND framework and therefore having them subject to the jurisdiction of the court is that it removes from my client the ability to set market rates which it believes are acceptable to both SEP holders and implementers alike, and replaces it with a structure which is going to get dragged into the courts for the courts to set that rate. Now, we respectfully say the free market is the position to properly ascertain the right to the collective licence. And we also say that significant harm can be done by the court coming in and imposing its views as to how the market should operate. One of the difficulties that arises is because the licence cannot be compelled, the moment the court comes in and looks at the licence on its current constitution and starts setting a different rate, if the SEP holders or the implementers change, universally it's not going to be accepted that the rate is still valid. So what you end up with is a spiral of every time the platform licence is issued, someone is either saying, well, this has gone up a bit or gone down a bit, and if resolution of that can't be reached, the licence ends up back in the courts again. And one ends up with a scenario, instead of the Avanci licence or something like it being a solution to the industry, where 89 licensors and 86 brands presently have been able to get themselves into a situation of access to the standard and remuneration to the patentees, avoiding holdout and hold up without getting the courts involved, we're suddenly left with that platform being continually dragged before the courts.
But as against that, given that we're all accepting, I think, that as a matter of practicality, global licenses are what are required, isn't there a danger on your approach of actually undermining the FRAND scheme?
My Lord, we say no, because as the ICLE explains, the big beast, those who are properly able to look at this, are able to look at the platform licence offered on the free market and say, is it better than bilateral licensing? If it's better than bilateral licensing, they will take it and they endorse it effectively for the benefit of the SMEs who can't challenge themselves. If, on the other hand, someone has put a pool together which is trying to take exorbitant pricing or exorbitant rates, the platform will fail because licensees will not sign up to it. The big ones, the ones who are ever capable of challenging it. So, fundamentally, this is my answer to ground one, fundamentally Tesla contends that the courts of England and Wales have jurisdiction to review and opine upon the terms of the Avanci licence. And what Tesla really wants is summarised well by paragraph 10 of the prayer of its particulars of claim. The most recent version we can pick up in the main bundle at 973. And here at prayer paragraph 10, what Tesla seek is a determination of what the FRAND terms would be for a licence between Tesla and Avanci covering the Avanci 5G pool, including the challenged patents. Now, of course, billions of commercial contracts are formed in the course of business throughout the world every year. However, the principle of freedom to contract means that the courts generally have no basis, or to put it another way, no jurisdiction to start reviewing and opining upon commercial contracts, unless the court is being called upon to rule upon a legal right or a legal obligation. Then and only then can the court review the alleged right or obligation and determine questions such as, does the obligation exist? What is its scope? Has it been breached? And then move on to questions such as of relief, such as should there be a declaration of compliance or non-compliance? Should there be an order for specific performance, damages, and so on? And this court in Unwired Planet held that the foundation of the UK's jurisdiction to review FRAND licence terms is the existence of an enforceable contractual obligation. And I can pick that up most conveniently in the first paragraph of Lord Justice Phillips' judgment for for the majority in the Court of Appeal on page 222 of the main bundle.
Paragraph?
It's paragraph 220. Sorry, let me find it. Sorry, I'm in the wrong place. It's page 292. I'm sorry. And it's paragraph 222.
Yes.
Citing paragraph 58 of this court's judgment in Unwired Planet, Lord Justice Phillips says, in the absence of the IPR policy, an English court could not determine a FRAND licence. It is the contractual arrangements which ETSI has created in its IPR policy which gives the court jurisdiction to determine a FRAND licence. And having in mind this basic jurisdictional principle, the bewildering feature of Tesla's case, at least by the time it reached the Court of Appeal, is that Tesla doesn't assert that it has any legal right against Avanci. As Lady Justice Whipple correctly stated in the first sentence of paragraph 245 on page 297 of the bundle, before this court, Tesla does not suggest that it has any legally enforceable right against Avanci, a point conceded in their skeleton, but still submits that there's a serious issue to be tried between Tesla and Avanci. And in the preceding paragraph, 244, Lady Justice Whipple correctly summarised that when obtaining service out, and initially before Mr. Justice Fancourt, Tesla had claimed to have an enforceable contractual right against Avanci as a matter of French law. But Tesla had accepted that its French law was wrong and voluntarily abandoned the claim to a contractual right. Tesla made another attempt before Mr. Justice Fancourt to get materially the same result based on the French tortious principle of good faith performance. But that too failed and wasn't pursued before the Court of Appeal. And to remind ourselves, it has always been common ground that Avanci itself has no direct obligation to license Tesla on FRAND terms. It doesn't own any SEPs, and it's never itself given any declarations to ETSI or anyone else. Now, as such, the existence and demise of these two attempts is important because they are both attempts to fix Avanci with an obligation enforceable by Tesla to license on FRAND terms. And Tesla sought to do this because that is what is required to come within the existing Unwired Planet jurisdiction. And having identified what is required and having failed, Tesla then came before the Court of Appeal, still seeking the same relief, a determination of the terms of the collective license offered by Avanci, but by then had given up purporting to have any pleaded legal right to such a license. And pausing there briefly, my learned friend Mr. Alexander, before the short adjournment yesterday, sought to say that Avanci had conceded at first instance that the FRANdness of the Avanci license was a matter for trial. Now, he came back after the short adjournment and quite properly clarified that that was not the case with respect to Avanci. Now, it's absolutely true that the point took on more importance in the Court of Appeal than it did at first instance, but that is because at first instance, Tesla was placing its case on an allegation that Avanci owed a contractual obligation to grant a FRAND license, or a tortious one on the good faith performance. When that was all abandoned before this Court of Appeal, but the case still pursued, the question of answering the alternative basis upon which Tesla was then putting its case had to be addressed for the first time.
I mean, correct me if I'm wrong, but I had thought it was rejected at first instance.
It was, my lord. It was rejected at first instance. So when they arrived at...
So Avance's case at first instance must have been just again no claim, no enforceable right against us, therefore no jurisdiction.
That was the case, my lord. Your lordship's absolutely right. But on the answering the two grounds that my learned friends were putting, when they abandoned the two grounds that they were trying to pursue, both under French law, and swapped over to arguing it without, my client accordingly responded and dealt with the case that was then being put.
Yeah.
Now, Tesla actually petitioned the Court of Appeal to reopen the judgment after they received it, on the basis that it wasn't open to Avanci to answer the case which Tesla had put in the Court of Appeal. That attempt was rejected by the Court of Appeal. It was the basis for ground 4 of the appeal to this court on which my learned friends were refused permission. And that's still in the main bundle at page 462, paragraph 30. So we respectfully say it really isn't open to my learned friends to take a procedural point on this now.
At the end of the day, we have to make our own minds up about this point.
You do, my lord. You do. So going back to what was decided in the Court of Appeal, Lady Justice Whipple precisely identified a fatal problem with the lack of pleaded case. At paragraph 245 on page 297, Her Ladyship refers to the lack of legally enforceable right against Avanci and then turns to the pleadings, culminating at line 8, about an inch into that paragraph, by noting that although Tesla pleads that it is accordingly entitled to a licence on FRAN terms covering the Avanci 5G call, which we would accept would support Declaration 10, Her Ladyship continues that the accordingly isn't explained anywhere in the pleadings. And as she says, I cannot see that it follows from the first two statements. She then considers Tesla's only pleaded case, which are all about the impracticality and onerousness of anything other than a collective license. In effect, contentions that the world could be better, but without any legal basis for bringing about such a change. And as the judge put it in paragraph 245, in short, I cannot identify any basis in Tesla's pleaded case for suggesting that the SEP owner's FRAND obligations are to be transposed to or read into a license granted by Avanci over its 5G platform. And then over the page at 246, that's page 298, Her Ladyship specifically refers to a number of the declarations, including Declaration 10, which I've just shown you, records that they're central to Tesla's case, but holding that by those declarations, Tesla seeks the court's endorsement of its claim that FRAND terms apply to the Avanci 5G platform license, but then expressly states that such claim is unexplained for the reasons she gave in the preceding paragraph. Now, Lord Justice Phillips, with whom Lady Justice Whipple expressly agreed, was less concerned about analysing the pleading, drawing focus immediately on the lack of legal right, whether pleaded or not. And we can go back to paragraph 222 on page 292 to pick that up. At 292, his lordship sets out the need for the contractual obligation from on-wire planet, as we've seen. Then at 223 through to 226, he explains the nature of the ETSI obligation as it applies to SEP holders, again, drawing all of his material from on-wire planet. At 297, on the next page, his lordship explains that each of the SEP holders who have joined the Avanci platform have given declarations to ETSI about licensing their own portfolios, so that each is separately contractually obliged to negotiate with Tesla the terms of a license to their own portfolio of SEPs on FRAND terms, and to grant such a license. And none of this is disputed. At 298, his lordship then explains that there is no possible construction of the ETSI undertaking which would oblige each SEP holder to license their SEPs on a collective basis, noting that Tesla has never made such an allegation. And we pause to note, for your lordship's note, that at paragraph 44 of its written case, page 40 before this court, Tesla confirms that it makes no such allegation. And the majority then holds, in the absence of any obligation to license collectively, Tesla cannot have any legal right to a collective license. And it then follows that without there being a legal right to a collective license, there is nothing to give the court jurisdiction to consider the terms of the collective license. As Lord Justice Phillips puts it at paragraph 231 on page 294, it follows from the above that there is no contractual obligation that would give the English court jurisdiction to determine the FRAND terms of a license of the SEPs on the Avanci 5G platform. And that is the judgment that my learned friends are appealing, yet it is quite telling that no time was spent on it yesterday at all. And before we leave this section, Lord Justice Phillips makes two further important points which feed into his conclusion. The first one is at paragraph 229 on page 293. Here, his lordship specifically considers whether it would make any difference to the contractual analysis that the SEP holders have chosen to offer a license on the Avanci platform. And he concludes that general principles of freedom of contract cannot and do not prohibit SEP holders from licensing via the Avanci platform, but that exercising that choice cannot create some legal obligation where none existed. And I'll return to this later when we look carefully at Unwired Planet, which also held, contrary to my learned friend's case, that even bilateral SEP licensing does not always have to be on FRAND terms. And the second important point which Lord Justice Phillips makes at paragraph 230 on page 293 is about what the nature of a collective license would be, making clear that if it was simply the sum of the rates of a stack of bilateral licenses, then the attempt to investigate the Avanci license would be pointless, because in his words, it would add nothing. The judge continues, pointing out that this isn't what Tesla wants. Tesla wants some new collective FRAND rate for all of the SEPs on the platform, what he calls a single collective rate, heavily discounted for bulk and convenience. And that illustrates the lack of correlation between the individual FRAND obligations upon which Tesla says it relies and the obligation necessary for the license Tesla wants the court to review. As Lord Justice Phillips put it, the owners of the SEPs have simply not agreed to license their SEPs on discounted collective terms. Now, Tesla now seeks indirectly to challenge the result reached by the majority. One might expect it to do so by attempting to say that the contractual basis for the court's jurisdiction set out carefully by this court in Unwired Planet is somehow wrong, or that the majority wrongly applied it in the Court of Appeal. What my learned friends say instead, in paragraph 44 of their written case, on page 40 of the bundle, is that Lord Justice Phillips asked himself the wrong question. He should not have asked whether Tesla has a legal right to insist upon a collective license, because Tesla has always accepted that there is no such obligation to offer one. Now, as we understand it, what Tesla says is that once SEP holders voluntarily join the Avanci platform, as a matter of commercial reality, the only license that the SEP holders can offer must be the platform license. And since they must be prepared to offer a FRAND license, that means the platform license must be FRAND. And just pausing there briefly,
please do go on, but as I understand it, there is a slightly different aspect to that, perhaps, which is that if you choose to license your SEPs through the platform, then in practice, in the circumstances pertaining at the date of commencement of proceedings, the only FRAND license of those would be a collective license through the platform.
That's how my learned friends seek to put it. But The difficulty with that is the bilateral always remains available. And what Lord Justice Phillips and the majority in the Court of Appeal were focusing on is if you had an obligation which is in the contract between the SEP holder and Etsy, although it's enforceable by third parties because of the stipulation, it is a contract between the SEP holder and Etsy. If that requires bilateral licensing, it cannot be changed to some other contractual commitment, whether as a matter of practicality, business efficacy or otherwise. The contract has its construction. And on the unwired jurisdiction, it's the contractual obligation which gives this court the right to interfere. It is not the court interfering simply because it would be a good idea for the court to be looking at business arrangements. You can't change the nature of a contractual obligation just because of the passage of time or the nature of business.
But I thought the argument added in a point about the law on declarations, which is that you don't need, in order to get a declaration, the legal right that you are positing, but one needs to have some sort of direct interest or serving a useful purpose, and that is filling, if you like, the lacuna that you're identifying, as I understood the argument.
I will come to that in a moment when we come round to what Lord Justice Arnold did. But we must understand from the outset, and the decision of the majority, that route to court jurisdiction is fundamentally different to held by this court in Unwired Planet.
But was that a holding, was that part of the ratio? Unwired Planet was a case where there was an infringement claim, wasn't there?
There was.
And the issue as to whether the court should set a rate arose in the context of a defence to the infringement claim, which essentially said you haven't given us a FRAND licence offer, so that the court's jurisdiction to rule upon the FRAND licence offer was, in a sense, to rule upon a point raised by defence in a claim where there was unquestionably jurisdiction to deal with the infringement allegation.
But the reason that the defence rose is because there was a legal right to the particular licence. And all of the justification through isn't tied upon this being founded on an action for patent infringement. It isn't tied to an assertion that because this is a defence to patent infringement, it's all put on the basis that by way of defence, the defendant raises a legal right to a licence. And the court says, right, you have raised the legal right to the licence. Now I'm entitled to look at what that legal right entails, which is the construction of the FRAND licence. It runs throughout Unwired Planet. It's there in the early paragraphs, especially. We'll look at it in detail in a moment. And it culminates at paragraph 58, which is what Lord Justice Phillips was quoting at the very beginning of his judgment.
Can I just test how far your submission goes? If an implementer, which was a member of the 5G platform, brought infringement proceedings in the UK against not an implementer, a patent owner, SEP owner, brought infringement proceedings against an implementer, and the implementer said, no, you haven't offered us a FRAND licence. And the SEP owner said, yes, we have, it's in the platform licence. Would the court have jurisdiction to rule upon whether the platform licence was FRAND, quoad that SEP owner and that implementer?
The action at this stage is up and running, but the preliminary issue that arises on that assertion is, does the SEP holder have a legal obligation to offer the platform licence? The very point that we're looking here.
No, the question would then be, not does he have an obligation to do it by a platform licence, but having asserted that he's done it by a platform licence, do you accept that that's a legitimate assertion, i.e., that a SEP owner can say where he's party to a platform, that platform, quoad me, is FRAND?
I say, from Avance's perspective, no. And if the implementer said, I don't want the platform licence, I am relying on my strict Etsy obligation, which is to a bilateral license, you end up at the same position we are now, which is the court having to decide whether there is a legal right.
But if that's right, where as a matter of construction do you get from the Etsy undertaking the conclusion that it cannot be performed by offering your SEPs on a platform?
Well, the starting point, we will look at the obligation, but the starting
Okay,
point...
well, I may be taking you too far ahead, but at some stage, I want to understand why, as a matter of construction, a SEP owner who is on a platform can't say that that's a discharge of his FRAND obligation.
The starting point is that the SEP owner can only ever offer a license of his own SEPs. It's Avanci who offers the platform license, and it's Avanci is the only entity which has the power.
But surely the SEP owner has made the possibility of a license of his SEPs available by putting them on the platform.
Oh, absolutely, my lord.
And what's more, Avanci does it as his agent.
As his agent, but only in respect of the collective license. The SEP holder still remains under the obligation to offer the bilateral license, and
Well, not if they fulfil their obligation by offering the license through the platform. I think that's what my lord is putting to.
Yes, I mean, but by all means come back later.
Yeah.
But I'm going to want to know how you can read, or how you say we should read, the Etsy undertaking as not performed by putting your SEPs on a platform which you say, and the court concludes, is FRAND.
Absolutely. I'm grateful, my lord. So just picking up where I was in my notes, the starting point of my learned friends' allegation in their written case that Lord Justice Phillips for the majority didn't consider whether the SEP holder's voluntary act of joining the platform changed his contractual analysis. My learned friend's allegations that he didn't do so is just wrong. We were looking at that in paragraph 229 of Lord Justice Phillips's judgment. He says the contractual analysis cannot change, and that must be right. The SEP holder's contract is with Etsy. It cannot be changed from an obligation for bilateral licensing of their own SEPs to an obligation for collective licensing simply because the SEP holder chooses to join the Avanci platform. Etsy, as the counterparty, hasn't even been told about the decision to join, let alone has it consented to any variation of the terms of the Etsy obligation with the SEP holder. And to be clear, what Tesla say is FRAND, and we can focus on that, they do not say that, do not want to say that the FRAND license through the Avanci platform is the sum of the bilaterals. As Lord Justice Phillips noted, they want bulk discounting and the like. And this is picking up my Lord Briggs's point, which is the SEP holder can't say that he's discharging his bilateral commitment, which is a rate for his SEPs, by offering it collectively with other SEPs which have completely different...
I have to say I'm struggling to understand that point. It may be worth your while taking a bit of time to explain it.
I'm grateful.
If the obligation is to offer your, looking at it from the perspective of the holder, your SEPs or at a FRAND rate, at the moment I'm struggling to see why, if you, the holder, maintain that the platform rate is a relevant FRAND rate, why it's not open to you as the holder to point to the platform and say to the implementer, there you are, that's how I am satisfying my Etsy obligation.
It's because the relevant considerations as to what would set the rate and the rest of the terms on a collective license are quite different to those set of considerations that would apply to a bilateral license.
But why does that mean that the collective one can't be FRAND? I entirely take your point that what is or isn't a fair rate for a collective license isn't just a sum of the individual rates that might be set up with 85 or more bilateral licenses. But I don't see why that means that the collective rate can't be FRAND.
it's the difficulty of referring to FRAND as something of a nebulous concept. A fair, reasonable and non-discriminatory rate, as opposed to a legal obligation to offer a certain set of terms. That's the fundamental difference.
Right, but there won't be nebulous if it's on the platform. You've got a rate, and you've got, at least in theory, the means to test whether that is a FRAND rate or not. I don't follow why that's nebulous.
I understand your Lordship's point. Perhaps I can come back to it, or just develop some of the basis law of this further, and then I'll come back to the point that my Lords are asking.
Certainly.
I mean, we say that, as far as we can see, Tesla gets itself into the mess it does by adopting the loose terminology of the FRAND commitment and ignoring the contractual obligation which founds the jurisdiction. As my Lords, Lord Briggs and Lord Sales correctly pointed out to Mr. Alexander yesterday, the case does require careful consideration of the ETSI obligation. It must do. And my learned friend agreed, but then failed to look at it in any detail, still less what this court said about construction in Unwired Planet. I'll come to that in a moment. But in many ways, my learned friends prefer to treat the alleged FRAND commitment as some overarching conceptual principle which attaches to the SEPs themselves. Indeed, the language which my learned friends use in paragraph 46 of their particulars of claim is that all patents in the Avanci pool are encumbered by FRAND declarations and therefore the FRAND obligations. And both of my learned friends yesterday variously used language consistent with the obligation running with the patents. And we say, with respect to my learned friends, this is a fundamental error. It's mixing up personal contractual obligations with an obligation which attaches to the property right. And whilst adopting such terminology allows Tesla to make wide-sweeping conceptual points about how the FRAND commitment ought to apply to anyone who's dealing with the SEPs, or could apply to the platform as well as to the bilateral obligation, we respectfully say it hasn't identified the legal basis for such an approach. Now, the court in Unwired Planet, and we should look at it, it's in the bundle at 3001. It starts at 3001 in the authorities bundle. We say the Unwired Planet was at pains to explain that the jurisdiction arises from the personal contractual obligation between the individual SEP holder and ETSI. That's paragraph 6. And although the contract is enforceable by each implementer because of the legal principle of stipulation pour autrui, paragraph 8, the contract is between the SEP holder and ETSI. We can pick up on Unwired Planet then at paragraph 4, where the court provides a careful overview of the legal background to the FRAND jurisdiction. At paragraph 4, just above B. Sorry.
Which page are we on?
We're on page 3001.
Yeah, okay.
Picking up just above B.
Yeah.
The court points out that to achieve the relevant objectives, the standard-setting organisation put in place contractual arrangements to which we now turn. At paragraph 5, just above D, ETSI is introduced, and we explain that it has, this court explains that it has adopted an IPR policy and a contractual framework governed by French law. Then just above paragraph 6, paragraph 6 just below J, when considering whether to include a technology in a standard, ETSI requires the patent owner to enter into an irrevocable undertaking or contract with it to allow implementers of the standard to obtain a license to use that relevant patented technology. At paragraph 8, over on the next page at 302, the court refers to the IP policy as a contractual document which requires the IPR holder to give the undertaking which leads to the stipulation. meaning a third-party implementer can enforce the obligation against the IPR holder. And this continues that the IPR policy falls to be construed in the same way as other contracts in French law. And then finally, at paragraph 58, which is some pages over on page 3014, that was the paragraph relied upon by Lord Justice Phillips below, that it is the contractual arrangement with which ETSI has created in its IPR policy, which gives the court jurisdiction to determine a FRAND licence. Now, my lords, Lord Sales, Lord Sales asked my learned friend yesterday about the evidence as to French contractual law. Regrettably, there's relatively little specifically on contractual principles, because the French law points which my learned friends were taking have fallen away. The law that was put before the court went to very specific points. We certainly say at this point that my learned friends can't be in a better position on their third or fourth case in this court, simply because they never supported their current position with French law evidence. No doubt they could have said, if they could have said anything useful, they would have done so, and we therefore say that the default position of English law must apply.
Can I just put to you a possible interpretation of that? I know it's a very important sentence in your case and indeed in Interdigital's case. There, the Supreme Court was only concerned with a direct fight between the SEP owner and the implementer. And in a sense, it was enough that there was a contractual relationship there. But looking in a wider sense, where I think now by concession there isn't between Tesla and your client, what the contractual arrangement does is to set, if you like, legal boundaries and metes and bounds which make the question whether a license is FRAND or what a FRAND license would be justiciable, rather than just something up in the clouds which the court can't get to grips with.
I understand the point that your lordship makes, and we actually see this. We'll turn to Vestal in a minute, where Lord Justice Burse, as he then was, deals with the relationship between the obligation and the task which the court has to deal with. We will also, I want to look at the policy behind the ETSI IPR policy so that we understand what it needs to cover. And your lordships will remember I spoke about the fundamental guarantee yesterday, which is very different to what my learned friends promulgate, which is everything must be FRAND, which then leads you to saying, well, why can't platforms be FRAND? And does the obligation go broader? So we've got to look at these points, but if I may, I'll proceed.
By all means. But have that as a possible alternative interpretation. The court wasn't thinking about the present problem at all.
Absolutely.
But if it's to have wider significance in this context, the question I'm putting to you is whether that's how it might, as it were, echo into this situation.
I understand, my lord. So standing back, we say Unwired Planet establishes the court's jurisdiction is based entirely on the contractual obligation. And we do say the commitment is not some nebulous concept which exists at large, nor is it a proprietary encumbrance on the SEPs themselves. Now, as a matter of construction, we can actually get out the IPR policy, which is at page 728 of the bundle. What I actually want to look at here is clause 6.1 bis on page 28. It comes after, as these bises do, after 6.1. And here, 6.1 bis...
bundle, page 728.
Sorry, it's page 728.
728, I missed the 7, thank you.
Here at 6.1 bis, it's expressly requiring that a SEP holder transfers their patent, that when the SEP holder transfers their patent, they ensure that there are terms in the contract of sale to ensure that the recipient also becomes subject to the ETSI obligation. And we respectfully say that would be wholly unnecessary if the obligation in fact encumbered the patent as property, which at times my learned friends suggested. ETSI recognises that this is a contractual jurisdiction, and fundamentally and fundamental to the court's jurisdiction. And we say that's no doubt why Tesla, since the outset of this case, has been trying to establish a mechanism in the French law for enforcing the SEP holder's contractual obligations directly against Appellants, but those attempts have all failed. Now, the majority in the Court of Appeal...
But doesn't 6.1 bis, the bit you've just quoted, say in its final sentence that even if you don't put in a personal obligation, it runs with the SEPs in any event? Isn't that what the last sentence is saying? The undertaking should be interpreted as binding on successors and interests, regardless whether such provisions are included in the relevant transfer documents. Whether that works or not.
Whether it works or not.
But that's what they were seeking to achieve.
Well, absolutely, that's what 6.1 was trying to do. But in order to try and ensure that that worked, and worked in all jurisdictions, they sought to impose upon those who were entering the obligation that they would arrange contractually for it to run. I think your Lordship's point is what they're trying to achieve is in the end, but they recognise that because it's contractual, simply saying it might not be good enough. Yeah.
Has anyone ever been thrown out of the ETSI grouping, so to speak, because they failed to honour the relevant undertaking?
Not that I'm aware of, my Lord. We'll look at what happened with people threatening to leave in just a moment, but I'm not aware of anyone being thrown out. Now, we say that the majority in the Court of Appeal rightly recognised what Tesla's case was lacking on a fourfold basis. First, no FRAND obligation on Avancia at all. Second, what FRAND obligations that do exist don't extend to oblige anyone to create a collective licence. Thirdly, a collective licence is different to the sum of a series of bilateral. What Tesla want is a single collective rate heavily discounted for bulk and convenience. And fourth, no voluntary action by a SEP holder, individually or collectively, can change the contractual basis of the SEP holder's obligations. And we therefore say that great care is therefore required with Tesla's loose references to the FRAND commitment. Most relates to either a utopian world in which all is FRAND, or the idea that the obligations somehow encumber the proprietary patent rights.
May I ask you a question? Supposing two SEP owners got together and said, well, actually, together we would like collectively to license our two SEPs, our two individual implementers, and we're going to do it on FRAND terms, and we'll get an agent to put together an appropriate rate for those two patents so that we can offer a single rate for our SEPs and do that together through our agent. Would that meet the ETSI obligation?
My Lord, what happened on that specific point, I'm going to come to the background on this, is when ETSI tried to mandate that in the ETSI IPR policy, it led to a massive breakdown and everyone threatening to leave, which is why we ended up with the minimum guarantee. So there can be no requirement that FRAND pushes through to the individual collective that your Lordship has in mind.
I don't think my Lord was putting to you a requirement. He's putting to you a practical solution that the two SEP owners devise for themselves, and they seek to meet their FRAND obligation by choice on a collective basis, as my Lord put to you.
My Lord is right. In effect, it's a very small version of an Avancia platform. Yeah.
Right.
Because
I think that's the point of the question. And then the question is, why couldn't the two SEP owners in my Lord's example seek to satisfy their personal ETSI obligation under Clause 6.1 by proceeding in the way that my Lord put to you?
So there's no prohibition on getting together collectively. There's no prohibition on offering a license. There's no prohibition in saying, I think this is FRAND, and you can take it or leave it.
Right. Forgive, is that a long run-up to saying, yes, they could do that?
But the problem is that what the implementer cannot do is to say that because that is actually legal fulfilment of the ETSI obligation, If I don't like the rate for the collective, I can bring it before the court.
But what if one or both the SEPs in this little two-owner platform threatens an infringement and is met with the defence, you haven't offered me a FRAND licence, and says, yes, we have, it's in here. Surely, is that not a is it not a justiciable question whether that FRAND licence is a compliance with the ETSI undertaking? I think you say it can't be.
We say it can't be, and the starting point that would end up in that dispute is that the collective says this is my FRAND offer, and the implementer says, no, I am entitled, you have only been sued by patentee 1, and I am entitled to a bilateral licence of patentee 1 SEPs.
But what if the implementer just says, I'm perfectly happy with a collective licence. I'm not insisting you just do a bilateral one with me. I don't suggest that your undertaking requires you to do that, but if you're going to do it collectively, I want that collective licence to be FRAND.
So in
at a proper FRAND rate.
In circumstances where, and this happens a lot in cases, unfortunately, it happened in some of the declaration cases like Rolls-Royce or whatever, where one party says, this is what I want to assert, and the defendant says, I'm going along with it. And you can go along with it to a certain extent, unless the court takes objection. But if the court suddenly starts looking at it, and when we get to the issues of Vestel, one of the problems that creates for the court is, well, what am I supposed to do here with the bulk discount, insofar as there is an agent dealing with, that's also taking a fee for organising matters? How do I fit that into the framework? And what Lord Justice Bursley then says in Vestel is that the problem of having a claim brought by consent in my Lord's scenario before the courts that isn't tied to a legal obligation is the claim is untethered by a legal standard, and it's actually very difficult to ascertain. So take the example of the two coming together, and one says, well, the administration fees, they're obviously naturally incurred, and I should be able to deduct them, the third-party fees. And the implementer says, well, there's no third-party fees in a bilateral to patentee A and a bilateral to patentee B, so how can I be made to pay bilateral fees? And you end up with a framework which doesn't align with any legal right. And whilst the court is capable of doing something, particularly when both sides are consenting, it doesn't mean the court should do it. And the court is at risk of putting itself in a position of saying, well, I'm being asked to make a decision, I can hear arguments for both sides, I can hear experts for both sides, and I can come up with a number, I can come up with a way forward. But the difficulty is it's untethered. My Lord.
May it be part of your case that you don't know whether many of the SEP owners who have authorised you to offer a platform licence incorporating their SEPs haven't taken a position on whether or not it's FRAND. Say that they say it's a reasonable rate, but they haven't taken a position as to whether or not it meets their FRAND commitment at all.
Or quite.
All of the examples that it may be said the court has put to you are cases where the SEP owner is saying, I am going to meet my FRAND commitment to ETSI by offering my patents through the pool. But if the SEP owner says, well, this is a commercial alternative, but I haven't got the first idea whether this meets a FRAND commitment that I own, and I can't really readily find out.
Yeah.
What I am prepared to do to meet my ETSI obligation is, separately from the pool or platform, to engage with and offer a licence to meet my ETSI obligation with any individual potential licensee who would like one. If they choose to go to the pool, they will certainly get a licence under my SEPs. But what I am not purporting to do is to hold the platform out on my behalf as meeting my ETSI obligation.
Your Lordship is absolutely right, and that's exactly how we see the platform as a commercial alternative. And in this present case, Interdigital, who are the only SEP holder present, and my learned friend Mr. Raphael will speak on their behalf, but has been absolutely clear that they are not holding the platform out as FRAND, that they stand by their bilateral FRAND commitment, and they are prepared to offer Tesla a bilateral license, but Tesla has never asked for one and doesn't want one.
And your position, it may be said, is we are not purporting to meet the FRAND obligation of the individual SEP owners who choose to put their SEPs on our platform.
Your Lordship is
we are
absolutely
offering
right.
this as a commercial and reasonable rate. The strength of our position will be tested by the market.
Absolutely.
But we aren't individually aware, so far as the particular SEPs on our platform are concerned, whether there is a bilateral license offer of some of those or not, and if so, what it is. We are simply a licensing platform, and it's wrong to put into our mouths any holding out by us of our platform as meeting the FRAND obligation of the individual SEP owners who choose to put their SEPs on our platform.
Your Lordship is absolutely right, and that is precisely how my client puts this case. That this is a commercial alternative on the side, that the SEP holders' obligations are dealt with bilaterally. They're expressly those bilateral obligations are expressly preserved in the agreements that my clients have with the SEP holders. And that is the route to ensuring the minimum guarantee, the fundamental guarantee, that remembering that the fundamental guarantee is to ensure that the standard won't be held up, that an implementer will always be able to get a license to each of the individual SEP holders' patents on fair, reasonable and non-discriminatory terms, and that remains.
You may also say, Mr. Dicks, and I'm not sure if this is part of your case or not, but certainly would assist me to hear your submission on it, is that that position would not preclude an individual SEP owner from saying, I am in fact meeting my FRAND commitment through the platform. But that is not a requirement of participating in the platform. No. It is not a position you take, and it's no part of your case whether all SEP owners take or would be prepared to take that position if challenged or not.
Your Lordship is absolutely right. I can't control. We will look at this in the context of some of the things which have happened in Germany. I cannot control what SEP holders say about my platform, and I can't control whether they are right or not. But it cannot make the platform subject to FRAND just because one particular SEP holder says that in their view they're no longer required to do bilateral licensing. If somebody disagrees with that, the right course of action is to sue that SEP holder and say, I want your bilateral license. That's what Tesla could do. It chooses not to.
Why should they say they want a bilateral license?
Sorry, say again?
Why should... Let's take your example where a SEP holder says, actually, what's on the platform is a discharge of my ETSI obligation.
Yep.
Why should the implementer say, oh no, I want a bilateral license from you? Why can't he just say, well, I accept that you can discharge your FRAND obligation with a platform license, but not on these terms. That one isn't FRAND, but one at, say, half the price would be FRAND.
Because
why on earth should the implementer say, oh no, I want a bilateral license? It's the last thing the implementer wants.
Because then you truly are... the temptation, because there is an existing obligation to FRAND hanging around, which is to the bilateral route, is to suddenly assume that because this platform involves SEPs, there must be a right to bring it before the court. And we respectfully say that there are lots of business transactions in the world where I was looking out the window yesterday and I saw the price of a double-decker bus go by. And there's been controversy over the price of double-decker buses, costing London £1 million or whatever. And the question is, can you drag the bus company into the court to say, well, how much are you paying for staff? How much are you paying for materials? What's your profit margin? Is £1 million really fair price for a bus? Now, the court can get involved in that, but in the sense of it's capable of going through the data and it's capable of going through the numbers, but there is no legal basis to drag normal commercial arrangements before the court.
But go back to my Lord Briggs' example of the infringement action in this jurisdiction, where the SEP owner brings the infringement proceedings and the implementer says, well, you owe the ETSI obligation and you haven't discharged it, therefore you can't have your injunction. And the response is, we have discharged it by making available a collective license, whether through a platform or, in my Lord Kitchen's example, just by an ad hoc bilateral arrangement between the two SEP owners. Well, isn't that then very precisely a legal issue that the court does have to resolve, because it's only by resolving that it knows whether to grant the injunction or not?
So the first point at that stage is the SEP holder says, that isn't my ETSI commitment. My ETSI commitment is to a bilateral license.
No.
Oh, sorry, the implementer.
I'm putting to you where the ETSI, the person subject to the ETSI obligation is specifically relying on the collective license that they have offered in discharge of their ETSI obligation.
Yeah. And if the implementer says, I've got no legal, your ETSI obligation is not discharged by a collective license.
No, he says it may be. It's just your collective license you're putting forward is too expensive.
Then you come on to the question of stage 2 as to, well, now let's look at the rate setting or whatever.
Yes.
In the context of something like the Avanci license, the SEP holder has no control over the rate. Avanci is the party that's...
But why does that matter? I mean, in the example I'm putting to you, the owner is positively relying on the offer through the license. That's what brings in the question of FRAND and whether it's satisfied through the offer of the license through the platform. Then, as I think I put it to Mr. Alexander yesterday, it becomes a matter of evidence as between the SEP owner and the implementer in a very precise way, because there's an infringement action on foot, as to whether what is being offered is FRAND or not. And then it's a matter of evidence whether it's FRAND or not. Now, that could be resolved actually without joining Avanci, although everyone understands that actually Avanci would be highly interested, if that is to be resolved, in being there and explaining and defending its rate. You say there's no basis for dragging someone like Avanci before the court, but in this example, what's, if you like, giving them an interest to come before the court, not being dragged before the court, is the fact that there is already an issue joined between the SEP owner and the implementer, precisely joined in an infringement action.
So the point is this, that the court in rate setting is very easy to use nebulously. Forget about rate setting. The allegation is actually one of breach of contract. It always is.
Yes.
But you have, or I have, an obligation to grant you a license on FRAND terms. Whether the SEP holder is asserting that they have discharged that obligation or not, the implementer seeking to enforce it, you've got to come back to, does the putative license discharge the legal obligation?
Yeah. Yes, I think that was all built into the questions I was putting to you, if I may say so.
It is built in, but the moment the SEP holder seeks to say, this is satisfying my legal obligation, it is open to the implementer to say, your legal obligation isn't to grant me a collective license, because in many ways you could say...
Well, it may be open to the implementer, but he doesn't want to do that.
But he can... So, as a matter of business or whatever, he decides, I'll consent to it.
So, sorry, consent to what?
So I will consent to the assertion that the one way in which you can discharge the obligation to license bilaterally is collectively.
Right.
But then what the court's doing, even though the parties are both going along with it, the court is then presiding over whether a putative license discharges a contractual obligation which isn't to a collective license.
Well, entertain the possibility that the SEP owner may discharge his contractual obligation by participating in a collective license. I mean, your submission is based on the proposition that it's not even arguable that he can do that. And you say, therefore, the court would only get into this by a sort of Alice in Wonderland consent regime under which, even though it wasn't even arguable, the parties have agreed that it can be done. But entertain the possibility that it can be done by a collective license. And that's what the SEP owner is saying. And the implementer is simply saying, I don't deny that you can do it by a collective license, but not on these terms. Why shouldn't the court adjudicate that? Well, there's no consent involved. It's just both parties recognising that the ETSI undertaking may be discharged by a collective licence.
And the owner asserting it is so discharged.
Yes.
And the implementer recognising in principle it may be so discharged, and then the only issue between them is collective licence at what rate?
And I understand where your lordship's coming from. If we come down then to that question, what rate? The court cannot change the rate because the SEP holder cannot control the rate in the platform, and neither can the court.
No, but if the court, I mean, the court can decide whether the offered rate is a FRAN rate. Mm-hmm. It's quite unlikely to do so without having a view about what a FRAN rate would be if it thinks that it's not a FRAN rate. And although, of course, the court can't grant specific performance against the SEP owner to change the rate because the platform doesn't work like that, then the question is whether if the court, A, takes the view that that isn't a FRAN rate, whether it's beyond the jurisdiction of the court to go on and say what it would be for the assistance of the parties.
So then you're back to the question that what has the court used as the metric in the assessment?
Yes.
Because in the assessment on the bilateral basis, where the SEP holder and the implementer are both there, the court is able to look at what's involved and doesn't have to get involved with questions such as bulk discounting. If the court is looking at a collective license, which affects many other third parties, the court then suddenly has to take into account some other legal metric, some other reference, and take a view on the bulk discount and who it should go to. Right. So the court then says at that stage, well, I think the savings from the bulk should be shared equally between the SEP holder and the implementer, for example. But the other SEP holders haven't even been part of that action. And the court suddenly made a declaration about this platform which involves many parties more than the two that are before the court, that take into account considerations of the SEPs being put in by other SEP holders and all of their interests. And the reason it's gone wrong is that the court is no longer opining on a right between the SEP holder and the implementer.
Well, it is. Sorry. Well, speaking of myself, that I was intending to put to you a case where the court is opining on a right. It's opining on whether what is put forward by the SEP owner is sufficient to satisfy its ETSI Clause 6.1 obligation. That's precisely what the court is opining on. Now, if the SEP owner is seeking to rely on a collective licence in discharge of that obligation, then it would seem to me that it has to be a suitably frand price offered taking account of the fact that it's a collective license. So you say, well, how could the court take into account distribution of bulk discount and things like that? The court would have to do the best it can, as it does on a bilateral basis, to take account of a range of circumstances. And we know from Unwired Planet it has regard to market practice and so on as the providing guide to the suitable way forward to apply what is a very open-ended standard.
I mean, as you know, next term we have that sort of case coming up for determination.
I know only too well, my lord.
But I mean, I only raise that to show that the actual determination of what is a correct rate or what is a frand rate may be enormously difficult, and there may be hugely divergent views about how you get to it. But that of itself doesn't deprive the concept that there is a collective rate which is quo ad a particular SEP owner frand of any legal content.
To be absolutely clear, I completely accept that the court can do a bean counting, putting it as low, a bean counting exercise, can do an apportionment. You can value my London bus and how much it's looked at. The question is whether you should and whether you actually have a proper basis for doing it.
Right, but the whole point of the question I've been putting to you is that the court has to. That's the only way it can resolve the dispute between the SEP owner and the implementer in the infringement proceedings that we gave as an example.
Respectfully, we say no, my lord, because bear with me that the implementer says this. The implementer says the legal right that I have is the bilateral right.
But he doesn't say that. I mean, the example you've been given by my lord is where the implementer doesn't say that. I think your assertion is that that is the only right you get from the ETSI undertaking. We're back to the question of construction, which is why you say, as a matter of construction, the ETSI undertaking only entitles the frand owner to grant a bilateral license and isn't complied with if he does it on a platform.
Is that your submission?
That is.
That is, right.
That is,
okay.
It is an obligation, and the reason it's an obligation is because that is the only thing a SEP holder can ever do. It's an obligation to license its SEPs.
Okay.
And we will look, if we get there, to the,
I'm sorry.
to the ETSI policy documents where what your lordships are putting to me was before ETSI, and you've got all the letters in the bundles where the SEP holders threatened to leave ETSI if they did what your lordships are doing. So the ETSI IPR policy was shredded and replaced by the fundamental guarantee. And that's why I say, looking at the principles of construction in Unwired Planet and what this court looked at when it construed the ETSI IPR policy before, it is a bilateral contractual commitment and nothing more.
So I believe there are cases where SEP owners have, in litigation, said the way we satisfy our frand obligation under ETSI is by offering a license on the platform, but they're just wrong.
No.
On your submission.
So they're the German cases, and I need
right.
to show you exactly what the law is in Germany.
Okay.
So that you understand what they're actually saying. They are not saying it's frand in the same sense, or not satisfying the court as frand in the same
All right. But transposing it to the example that we've been using to test your submission, you would say that the SEP owner would be wrong if that's what they tried to assert in the English court in these infringement
And
proceedings.
before we get into the Travo to see if you're right, I think I need to be clear. Your submission, I think, is not merely that it shows that the SEP owners are not obliged by their ETSI undertaking to provide their SEPs licenses on a platform. They're not even entitled to.
No, they're entitled to provide their SEPs on the platform, but not
No,
in
but
discharge.
not in discharge.
discharge.
They're not entitled to by way of discharge of their ETSI undertaking.
Your lordships,
I'm sorry, I should have.
right. And just one further point I've made before I just move back to where I am in my note, is that you've got to be very careful with this, because if you do look at it and say, well, with business common sense or practice or everything else, this court hereby declares that this platform license is FRAND and the rate is X pounds. What happens to the SEP holders who haven't joined the platform?
Who haven't?
Haven't joined the platform yet.
Well, they don't participate. That's their prerogative.
Exactly, because at the moment they're entitled to bilateral licenses, but it's going to be absolutely assured that they will be dragged into court saying the court in the United Kingdom said that the only thing that could be FRAND is a platform license and the rate is X dollars. And this SEP holder, in breach of their ETSI obligation, has not joined the platform and is forcing us to go bilaterally. And we say as a matter of practicality, that just emphasises the fact that the SEP obligation cannot compel anyone to join a platform.
No, but I don't think anybody's suggesting that
can't change.
I don't think anybody's suggesting it can compel anyone to join the platform.
Right.
The issue is whether they are entitled to discharge their ETSI obligation by a platform licence on FRAND terms. And I think you're saying, no, they're not.
I'm saying absolutely they're not. Absolutely they're not.
Yeah, I just want to, absolutely, that's what you're going to, that's what you want to show the travaux préparatoire established.
I will, my lord.
Yeah.
So I just want to touch on Vestel first. I can pick this up in Vestel in page 3046 of the bundle. The action was commenced by an implementer, Vestel, seeking declarations as to RAND terms under License for Video Coding Standards, ITUT. Access Advanced was a pool administrator. Philips was one of the owners of the SEPs. Originally, Vestel has sought to rely on competition law as the legal basis, but abandoned that before the Court of Appeal. The consequence was that Vestel has identified no legal right to a RAND pool licence. And at 3051, Lord Justice Burst records that the procedural background, notable by its absence in a claim, Vestel has, notable by its absence is a claim by Vestel that has a legally enforceable right to a FRAND licence. And at the end, the argument based on the inherent jurisdiction is not founded on a claim to a legal right to a FRAND licence.
So is this right? This case was not the one in which reference was being made to whatever was the relevant obligation. Is this an ETSI case?
No, it's an ITUT case, but nobody has ever suggested that the obligations are materially different between ITUT and ETSI.
So this is a case, is this right, where no one, for whatever reason, was seeking to rely on what is for us clause 6.1 of the ETSI?
Expressly, absolutely, my lord.
Right.
Now, paragraph 78, Lord Justice Burst holds that the need for a legal standard against which to judge the claim declarations is important. Now, he cross-refers to paragraph 117 of this court's judgment in Unwired Planet, but his wider treatment of the jurisdiction is actually set out in Vestel at paragraphs 46 to 48 on 3052, where he keeps going back to Unwired Planet and the contractual basis for the jurisdiction, starting by picking up paragraph 58, setting out the court's jurisdiction to rule upon the contractual defence arising from the undertaking given pursuant to the ETSI regime. Then at paragraph 48, he makes reference to 117 of Unwired Planet that the proper contractual construction of the ETSI IPR policy is what guides the legal basis for the court's assessment of FRAND, concluding the legal basis for the particular FRAND obligation on which the court is being asked to adjudicate needs to be identified. Going back to paragraph 78, Lord Justice Burst rightly explains that there's no such thing as a freestanding FRAND claim. Although Vestel refers to the ITUT rules, it doesn't contend that these proceedings that they have legal force. We respectfully say that this case is identical to the position in Vestel. As Lord Justice Burst explained, for the court to have jurisdiction, there must be a legal right to the specific licence which the court is being asked to adjudicate upon. In Vestel, no such right was being alleged at all, notwithstanding that Vestel was referring to the ITUT rules, as the judge noted. What was missing was the contention that those rules led to a relevant legal obligation. Now, my learned friends for Tesla say that they're in a different position because they do mention the individual SEP holders' obligations. And to support their positions, my learned friends refer to paragraph 71 of Vestel, where the judge says in the context of gateways, I'm prepared to accept that if Vestel did claim to have a legally enforceable right against a patentee or licensing agent of a patentee, whereby Vestel were entitled to be offered a FRAND license under the UK SEPs in the HEVC advanced pool, then the subject matter of that particular claim would be the UK SEPs. Now, my learned friends say...
I think that's setting up the infringement example, isn't it?
Well, it's setting up the jurisdiction by the implementer to look at the HEVC advanced pool. And what we say, my learned friends, have overlooked is Lord Justice Burse's express and careful statement that the necessary right you would have had in Vestel would have been a FRAND license singular under the SEPs to the HEVC advanced pool. In other words, a right to be granted a single license to all of the SEPs in the pool. We respectfully say that Vestel doesn't support the contention that a right to something less than a collective license is sufficient to give the court jurisdiction to review a collective license.
But in 71, he's dealing with a separate issue, isn't he, about whether you get through Gateway 11.
He is, my lord, but that's the bit my learned friends fasten upon. And we say even if they can fasten upon this, they're missing the fact that he's talking about a single right to the collective license, not the individual license. Now, I can also importantly pick up in 78 that Lord Justice Burse is also focusing on the need...
Well, sorry, just on that, I'm not sure Lord Justice Burse here is expressing a view one way or the other as to whether you can only have a license SEP by SEP or whether it can be done collectively.
My lords, I'm trying to respond to a point that my learned friends made. We say,
right,
if anything, it's the collective, but it certainly doesn't support the individual.
I see. Thank you.
But while I am in 78, which is of better help to me, Lord Justice Burse also focused on the need for a practical alignment between the right founding the jurisdiction and the task before the court, explaining that the court must have a legal standard against which to judge the claim, without which, he says, at paragraph 79, the court would be left to assess a freestanding claim untethered to any legal standard. And we say that the point he is making is that in a licensing dispute, the contention is that there is an obligation to grant a license of a particular type. And the court's practical task involves considering whether some putative license satisfies the obligation. But if the obligation and the putative license are not coextensive, the court has no way to decide whether or not the license discharges the obligation. And that's why the judge put it, that there's no legal standard against which to judge the claim. And I take my Lord Sales's point that forced into a situation, the court can try and do something, and sometimes that has to happen. But in terms of the jurisdiction, having the right and having the license which is said to discharge the right, being coextensive is important, and that's the point the experienced judge, Lord Justice Burse, was making.
I mean, I think the point that I was putting to you was if one accepts that one can have discharge of the Clause 6.1 obligation by the offer of a collective license, and that is what the owner is saying discharges their Clause 6.1 obligation, well, then one would expect that the license that is being offered would have to satisfy appropriate FRAND terms appropriate for a collective license, which is what the owner is relying upon. And in order to answer that, that's not untethered. That simply arises out of the FRAND obligation. And as happened in Unwired Planet, the court has to search around how to apply this very open-ended standard, and what it tends to do is look at commercial practice. That's exactly what happened in Unwired Planet.
And Your Lordship has made the point which I was going to go on to make. I'm going to skip through. What we see continually in Unwired Planet is that where there are disputes as to whether or not a term is implicit in what's going on, the court keeps going back to construing the legal obligation in order to ground itself in the determination of the dispute between the parties.
It's going to be said against you that the difference between this case and Vestel is really encapsulated in paragraph 78, which is that they weren't saying in Vestel that there was anything in the ITU rules that gave rise to a legal obligation. But Tesla are saying in this case that the ETSI undertaking does give rise to a legal obligation, that it's agnostic as to whether it's performed bilaterally or multilaterally, and since you, through an agent, well, not you, since the SEP owners, through you as their agent, have put into the marketplace a multilateral one, there is a legal obligation by reference to which the frandness of that license can be judged.
And the answer I put to that is that, yes, absolutely, in Vestel they had no legal right that they were seeking to rely on at all. But in this case, they don't have a legal right to the collective license, which is what they want the court to adjudicate upon.
But I can understand in relation to your submission that you can't do it by a collective license, but if that is one way in which you can do it, then does that point still hold good? I quite accept they can't insist on a collective license in this. Well, they may say it's the only one that's franned, but in principle it's not purely collective. But if you can do it by a collective license, and that is how it's been done in this case, well, why isn't there a legal standard by which the frannedness of it can be judged?
So it comes down to this. My client does not say the collective license is franned in the material sense.
No.
Interdigital, the only SEP holder present, does not say that his obligation is discharged by the Avanci pool. No other SEP holder is present, and the attempt to bring all the other SEP holders in by representative action has failed. The only person who says the collective license needs to be franned is Tesla. They turn up and they have chosen to point at a commercial arrangement and say, you've got a legal obligation to license your business activity in a particular way. And my client says, if that is the jurisdiction that brings you within the court, the starting point for that is you have got to establish your legal entitlement to what my client is offering. And when you cannot have a legal entitlement to what my client is offering, I cannot be brought into court for breach of my obligation because what I'm offering doesn't ascribe to some standard.
Because your submission is that neither Interdigital nor Avanci is holding itself out as purporting to meet the ETSI obligation that the individual SEP owners have undertaken.
Absolutely, my lord. And to bring me into court for a failure in the discharge of that obligation, because that's what the case is about, a failure by my client to discharge that obligation, Tesla's got to show your lordships that I'm under an obligation, or that Mr. Raphael's client is under an obligation.
And this is, in a sense, a fallback submission, or it's a second self-standing submission, as I understand your case, from the primary submission you've been advancing, which is that it's simply not possible for anyone to meet an ETSI obligation through a platform, even if they're holding themselves out as having done so.
Absolutely, my lord. We say you can't do it, but in the particular circumstances of this case, because you can't do it, Tesla's been unable to show that we do.
Right. Isn't part of the problem, if that's the right way to put it here, that Tesla is seeking to get clarity on its position and the likely position in advance of launching products into the market? So we're looking forward to try to estimate how people will behave. Has Interdigital undertaken not to rely upon the offer of the licence as part of its possible defence to an argument by Tesla, if they do launch, that Interdigital are not entitled to enforce their SEP?
Formally, of course, that's an answer. That's a question for my learned friend, Mr. Raphael.
I understand
My
that.
understanding is that his position is he is not saying and has no intention of saying that the Avanci licence is frowned.
Right.
He stands by his bilateral commitment and he is prepared to offer Tesla a bilateral licence.
So he's not undertaking in these proceedings.
I believe that's the case, Madam.
So we're in a situation where, because of the juncture at which this issue is being raised, we can't be sure one way or the other whether that will be the way in which notional infringement proceedings would play out on the part of Interdigital. And then the question, isn't this right, whether it's appropriate or helpful for this court to give a declaration against the possibility that that might happen.
Quite, and especially in circumstances where my client's platform is the one that's being determined. My client says SEP holders cannot do this. They cannot.
SEP holders can't do what?
They can't seek to discharge their ETSI obligation.
Yeah, so that's your case, and I think we need to allow you to develop it some more, because that's obviously a very important submission. Because if you're right about that, a lot of the case falls away.
Yeah. I'm going to speed up. I guess skip a few things briefly. We say that where Lord Justice Arnold got it wrong, just to deal with the dissenting point, he went straight into the question of when the court can issue declaratory relief without ever looking at the unwired jurisdiction at all, not ever looking for the contractual obligation. And we respectfully say that, as the majority pointed out, you don't get to questions of arguable relief or useful purpose or anything of that nature until you've already found a legal right. And you find that in Unwired Planet, you find it in Vestel, you especially find it in Nexus before this court, where this court, although it was dealing with a rectification claim, took the time to look at Rolls-Royce, which is a declaratory case which doesn't have an underlying legal obligation, and said, this court said that Rolls-Royce is no longer good law. So we say you have got to look at you have got to look for the legal obligation, and it's no answer that Lord Justice Arnold spent many paragraphs looking at could the court do anything useful if it's already got jurisdiction. Now, I'm going to get on to trying to get on to the substance of the two limbs that arise from my learned friends, paragraph 27 and 27.2. 27.1 is supposed to be about the construction of the Fran commitment. 27.2 is supposed to be about commercial reality. Starting with 27.1, we say that what they say about construction is very odd indeed. They've given up on French law and given up on allegations that the ETSI IPR policy imposes any obligation on my client. And having failed, it now tries to reverse the burden by saying that it's for Avanci or Interdigital to point to anything to warrant construing the FRAND commitment as ceasing to apply or being abrogated when a SEP owner chooses to license jointly with other SEP holders through the pool. And the fundamental problem with this is that it depends entirely on the existence of a FRAND commitment, which requires FRAND to apply to all SEP transactions unless Avanci or Interdigital prove an entitlement to its ceasing. My learned friends make no attempt to follow this court's contractual approach in Unwired Planet. They don't say the court was wrong in Unwired Planet, and they don't say the Court of Appeal misapplied it. Paragraph 29 of their written case. paragraph 29 of the written case on page, 36. They say French law applies to the process, well, that's common ground. Then at paragraph 30, rather than advance an actual construction, my learned friends simply materially misquote the ETSI IPR policy to assert that the obligation is to grant licenses on FRAND terms. Now, the full obligation is actually set out by my learned friends on page 34, and it's actually to be prepared to grant irrevocable licenses of their own SEPs on FRAND terms. And we respectfully say the difference matters. My learned friends' misquote of paragraph 30 now implies, without any justification, the SEP holders agreed that they will only grant licenses on FRAND terms. We say that's not right on the language actually used and completely ignores that ETSI was concerned only to ensure that the bilateral SEP license would always be available from each SEP holder. Moving on to paragraph 31, relying entirely on their own mischaracterisation, they say the majority's conclusion that offers cease to engage the FRAND commitment when operating on a platform must be wrong. But when we go to the actual language of the obligation, it clearly requires each SEP holder simply to provide what we've called the fundamental guarantee. They must always be prepared to grant bilateral licenses to their SEPs on FRAND terms. There's no other prohibition on the SEP holder's freedom of contract, nothing to prevent a SEP holder licensing in some other commercially acceptable way, including through a platform.
But there's no reference to bilateral in the undertaking either, is there?
No, but it's of their own SEPs, and it's to and implement.
Yes, but if you join with somebody else in a platform license, and all your own SEPs are in the platform license, it's still a license of your own SEPs.
So the obligation is to each individual SEP holder, and the only obligation an individual SEP holder can offer is to license their own SEPs.
But my Lord's putting to you, they will have done.
And they will have done, but there is nothing to compel them. This was the point that was being made by the majority in the Court of Appeal. There is nothing here to prohibit them licensing in any other way, and nothing to compel them to join a collective platform. They've always got to be, the whole point of the minimum guarantee, the fundamental guarantee, is to avoid hold-up, to ensure that we do not end up in a situation where the standard cannot be put into effect because somebody holds a monopoly patent on the platform and either won't license it or won't license it on FRAND terms.
But hold-up can be avoided either by a bilateral or a platform license, can't it? I don't see why the obligation to avoid hold-up points one way or the other on the critical question of whether this only applies to bilateral licenses.
I mean,
Indeed, I just add one further comment to that. As I understand Mr. Alexander's case, he goes one step further. He says that where you have chosen to put your SEPs on the platform, and it is working jolly well, it would not be FRAND to require the implementer to take a bilateral license, because that will indeed cause a delay and it'll cause a great deal of hold-up, whereas when the license is available already on the platform, that's obviously the way to go, he says, and that is indeed the only FRAND option in those circumstances.
But that leads to an impossibility scenario. Each individual SEP holder is given their obligation and they are required to ensure they fulfil it. But a SEP holder on the platform has no control over the rates on the platform. No control whatsoever. They cannot ensure they're meeting their obligations. The way that they ensure that they're meeting their obligations is by always being prepared to grant a FRAND license.
I mean, they can look at what's being done on the platform and they can say, that meets my FRAND obligation. That's their way of ensuring that they do it, that they look at the price and they're happy to stand behind that price.
But the problem is that the price is justified by what everyone else puts on the platform.
Yeah.
And they cannot, one of the things that my client has to be very careful about is not turning this into a cartel, because you cannot share pricing arrangement between the SEP holders. They cannot be involved because the competition authorities would be down on the platform and the SEP holders like a ton of bricks.
Yeah, but they can still look at what is being charged, and they can still say, I will assert that that is a frowned rate, and they can deploy evidence to support that argument.
But they can ensure the requirements of ETSI, that is the minimum guarantee, that before platforms even existed, what ETSI wanted to happen, what ETSI saw was needed, was a minimum guarantee that you cannot hold up the platform because each SEP holder can be required to bilaterally license their own SEPs, because they can't license anyone else's, license their own SEPs on FRAND terms. And the fact that a platform has been created over which the SEP holders have no control, one has to be incredibly slow to say that what ETSI intended was that the obligation would flow on so as to prohibit any other commercial arrangements.
Presumably, each individual SEP owner on the platform will be getting a royalty for each car that implements the 5G standard.
Yes, my lord.
And that figure will, one way or another, represent the income for that licensing of its SEP, derived from the platform. That's a starting point. That doesn't require any separate analysis of other SEP owners' relative values compared to the particular SEP owner in issue. One has a royalty rate being paid to the SEP owner directly by the platform.
Your lordship is right, but the allegation that comes from an implementer, someone like Tesla, is that the rate on the platform is non-FRAND, is a breach of the commitment. And let's just say I've said to, I'm a SEP holder, and I've said to Avanci, look, I do not want more than $1 out of my SEPs, because if I take more than $1 out, I won't be FRAND, I'll be charging too much. Fine, says Avanci, you're only going to get $1. But then Miss Pickard says, well, I know I'm only entitled to $1 too, but actually I want $5, and I won't agree to this without $5. Avanci goes along with it, let's assume for present purposes, and the rate for the pair of us is $6. I'm in breach because of the control by the exercise by Miss Pickard, over which I've got no responsibility.
But the SEP owner knows what the overall, as I understand it, remind me what the get-out provision is under the agreement. Can a SEP owner can leave the platform?
6 months' notice.
On 6 months' notice.
Like that, yeah.
But even before they first join the platform, they presumably know what the platform rate is going to be charged to the implementers.
Yes.
So they know what they're going to get out of it, and they know what the rate is that's going to be charged out into the marketplace. They may not know what everybody else is going to get out of it.
Not quite, because the number of SEP holders on the pool changes all the time.
Yeah.
Tends to go up.
Yeah.
Changes all the time, and what each SEP holder gets out of the pool, the platform, is the money in shared on a distribution arrangement of the current members.
Yeah.
So what the SEP holder is getting out of the platform changes as the composition changes.
But the rate doesn't change.
The rate doesn't change to the implementer. Yeah. I mean, so it's a really complicated free market arrangement, and it is incredibly difficult for anyone to look at this and from a SEP holder's position say, hey, I know I'm going to be good. And then what happens? I've joined up to it, I'm committed to it for the next 6 months is what I've said, and let's assume that unbeknownst to me, one of the major SEP holders holds a big chunk of the stack, has given notice and is out of the platform. The rate is still going to stay at the $32. My amount to take from it is going to go up. And every implementer is suddenly going to accuse me of non-FRAND behaviour. What one ends up doing with this, if one starts trying to impose FRAND on this platform, is you have to destroy the platform as it exists. And the court has to take over responsibility for looking at what the rate should be from time to time between those who want a collective rate. The court would be setting up a brand new jurisdiction for platform licensing when none exists under ETSI or most of the other standard setting organisations, and the market has found a free market solution to this that works for everyone. It works for the small enterprises, it works for the medium enterprises, it works for the large enterprises. There is good economic reason for saying the court shouldn't be regulating it because it safeguards against the fundamental commitment, fundamental guarantee, which is that particularly big entities like Tesla always go to Interdigital and get a price.
Can you just tell me, what's the duration of the platform license at the given rate?
It's I believe it's confidential, but it does run for a number of years.
And there's no power in the platform owner to change the rate, reduce the rate? I'm just thinking if a SEP owner with 50% of the licenses leaves, is there nothing the platform owner can do to adjust the rate?
One of the issues with the platform is there's I would call it the secret sauce in how the distribution mechanisms work. It is gauged to be successful in the market to both sides. Because if, to posit your point, Lord Briggs, if some of the major SEP holders go, the implementers then say, well, I'm not getting value for money anymore.
Yeah.
And I'm off. And we'll go back to bilateral. Or some new platform, some yet unnamed commercial entity will say, hey, I can do this better. I can get better engagement from the SEP holders, or I can get a better price for the implementers. This is genuine free market economy.
If one didn't reduce the rate when half the SEP owners left, for example, that would put the implementers in an impossible position because they'd have to pay those SEP owners who'd left separately. They'd have to, on the assumption the invention's been incorporated into the standard and they want to sell 5G connected cars, they're going to have to pay the SEP owners whether they're members of the platform or not. If half leave the platform rate would have to drop, surely.
Can I just add to that? I had thought that if the license runs for several years, so say at 1st of January this year, a license is granted to an implementer, and 6 months in, a SEP holder who holds 50% gets out. It doesn't negate that license, does it?
No.
So what he does when he's in is to allow Avanci as his agent to grant a license that may run for years. So all he does by getting out, as I can see, is cutting off his nose to.
No, sorry, I haven't explained it properly. That when a SEP holder puts in, the implementers buy on a per car basis, so they buy from time to time. And at the time they buy each individual license, they get the license to the SEP holders who are in. So if a SEP holder leads, next month you don't get a license to their SEPs because they've gone.
For the new cars.
So again, for your new cars.
The old cars will
your old cars were licensed at the time you had the license.
So although the license runs for years, it only applies to cars on a sort of month-by-month basis.
You pay as you go. And as the SEP holders go up, you get more of the stack. As the SEP holders go down, you get less of the stack. Hopefully, as long as we don't create a scenario where the SEP holders want to leave in droves, the number of SEP holders will go up and up and up. And at the moment, there's more than 90% of the stack being licensed, which means that car manufacturers aren't being dragged into the court for being unlicensed. What generally will happen if SEP holders start falling away because, for whatever reason, the pool no longer works for them, is that the implementers may still take that. But what they need to do instead is now go round to all of the SEP holders who've left, especially the big ones, and agree bilateral licenses. And they, at that stage, will definitely be paying more than $32 because they'll be paying $32 for what's in the platform, plus whatever they have to pay to the people who've left. Now, we've set out in our written case, I'm very, very aware of time, we set out in our written case our answers to each of the individual points that are taken on the 27.1 and 27.2. I'm not going to have time to go through them individually. One of the points that my Lord Briggs did raise with me is the issue of what's said by SEP holders in foreign proceedings. Take it shortly. Firstly, the obligation can't change just because somebody asserts something. Secondly, what they're looking for in Germany is very different to in the UK. They have something called the Huawei and ZTE dance, which is set out in the Unwired Planet judgment, and it's explained. It's a competition law approach, and it requires that before asking for an injunctive relief, you need to show that you have been a willing licensor and have made some sort of effort towards licensing. Now, in some of those on the previous 4G platform, some SEP holders have said, well, I started the ball rolling by offering the Avanci 4G license, and the implementer hasn't responded, or hasn't responded adequately. And the German courts have said on a very low threshold basis, well, look, I can see the implementers at least willing to license, the SEP holders at least willing to license, the implementer has done nothing, I'm proceeding to the injunction, and that is uncompetitive. That is not the same as a scenario that would arise if an implementer said, as we were positing earlier, sorry, a SEP holder would say, as we were positing earlier, this is my FRAND license, and the implementer said, no, it's not, I'm entitled to a bilateral. It's a slightly different scenario. But the big problem with it is that wouldn't happen in this jurisdiction. If a SEP holder said, after a finding of infringement, this is a FRAND license, and the implementer said, no, I'm entitled to a bilateral, then the court isn't going to injunct them before resolving that issue. And I don't want to get back into, again, as to how you resolve the issue. But the point is there isn't a risk of injunctions because preemptively you haven't looked at the FRAND license. What my learned friends are really complaining about, as far as they're complaining about what's happening in Germany, is saying that this court should instigate a mechanism for a review of FRAND licensing to stop the German courts doing something my learned friends disapprove of. And we say that can't possibly be right. That isn't the role of this court. I'm very quickly going to pick up.
Mr. Lister, are you going to take us to the Travo, or leave us to do that as a matter of homework?
That's the point that's the one point I need to pick up on.
Yeah, I mean, it seemed to me that that's a very important part of your case.
Thank you. Right. Yes, the Travo. So we picked this up in our written case at paragraphs 54 to 58 on page 130. And this is where we explain, contrary to Tesla's contention, when the OPR policy was originally drafted in 1993, Etsy attempted to severely limit the freedom of contract. It wanted to stop SEP holders licensing outside of the FRAND regime. And it included expressly within that joint ventures, such as the forming of pools or platforms that were under the joint control of the SEP holders. Now, we don't accept my learned friend's contention on his feet yesterday that a pool controlled by the SEP holders would not be a joint venture. We say it clearly is. But the important point is my learned friends don't respond at all to the wholesale change in approach which occurred between the 1993 and 1994 change in Etsy policy. The original 1993 approach was heavily criticised by SEP holders as unduly restricting their freedom and discouraging their participation in Etsy at all. They threatened to take their technology away from Etsy. And your lordships have in the bundle at page 739 raft of letters to Etsy from major contributors to the standard, refusing as a whole to subscribe to an IPR policy scheme that was overly imposed upon their freedom to contract and threatening to leave Etsy. I won't go through the individual letters. Now, unsurprisingly, the restrictive policy was quickly abandoned and was replaced by the slimline fundamental guarantee, which we have and continues to this day. And we say this material change in policy is important. And at paragraphs 36 to 37 of our written case, we explain that in Unwired Planet, this court expressly relied on the fundamental change between 93 and 94 when rejecting, as a matter of construction, the contention of a most favoured licensee clause. The contention was that most favoured licensee would be inherent to the non-discrimination limb of the FRAND obligation. In other words, if I've offered to license you at $5 and then subsequently do a deal at $3, there should be an ability to come back for the $2 difference. Now, exactly the same, we say, should apply here. This court should not construe, cannot construe the obligation to have the effect of restricting SEP holders from licensing other than on FRAND terms, when that was precisely what Etsy abandoned in 93. I can also pick up, at this point, paragraphs 125 to 126 of Unwired Planet.
Just before you do, obviously I'm going to read this correspondence, which starts at 739.
Indeed, my lord.
I'm only on the first page of it at the moment, and the point you're trying to make doesn't spring out of that page. Are there any, as it were, purple passages that you say make your point? I mean, by all means, come back later, but it would certainly help me to know where in this correspondence this particular point is being taken. Not that we shouldn't have to use our best endeavours to ensure that a joint venturer does it on FRAND terms, but that we shouldn't even be entitled to say that a collective licence is FRAND.
Yes.
And in fact, I mean, that would be have a tendency against freedom of contract under the Etsy regime, because in effect you're saying that the Etsy undertaking has to be interpreted as removing what would otherwise be an option in SEP owners as to how they meet their obligation, whether collectively or in a bilateral arrangement, because you're saying, well, it has to be bilateral. So at the moment, pointing us to correspondence emphasising the importance of freedom of contract would seem to me, at any rate, at this stage, to have a tendency against your main submission. But do point us to what you want us to look at.
We say that you must always be able to have, so it's about what you can enforce. You can always enforce your FRAND right against each individual SEP holder. But there's nothing to stop you going commercially and finding something which is attractive to the commercial market. And if what you're offering commercially, it doesn't matter whether it's FRAND or not, because if it's better than the minimum entitlement, the series of bilateral contracts, then it's better than those contracts, right. And there isn't a need for it to be.
And I follow that this may be an important point to make against Mr. Alexander's primary submission, his paragraph 27.1, where he seeks to get what might be characterised as a fairly extreme interpretation out of clause 6.1, that you can only make offers which are FRAND. But if I may say so, that doesn't establish what I understood you to be taking us to the Travo for, your rival contention that the only FRAND offer that can be made is bilateral. But there are two separate things. I can see the relevance of freedom of contract as being an answer to Mr. Alexander's first limb of paragraph 27. I'm not sure how it supports your separate contention.
The way it works under the separate line is you can always offer something that's better than FRAND. It doesn't discharge your FRAND obligation, But we say, I mean, we always have said...
But sorry, I thought that your submission was that the only way the obligation under Clause 6.1 can be met is by a bilateral licence. I thought that's what you were leading up to with this.
Your Lordship is absolutely right, and that is how we construe it.
Yes.
And we say it works because having the freedom to be able to reach licence agreements outside of FRAND has already taken care of ETSI's concern.
Right. I mean, I can see how it might work, but what at the moment I'm not seeing is how it's supported by the Travaux, and I think we're asking for some assistance with that.
The purple passages I'm looking for are those that support your point.
Yes.
But you cannot do it on a platform. You cannot discharge your ETSI obligation on a platform.
Or on a collective basis.
I think I would struggle in the Travaux to say that you can't. What it shows you is what ETSI was seeking to achieve. What its policy was to set this fundamental guarantee. That's what they were concerned about. You only need to fall back on the fundamental guarantee if commercial stuff isn't working.
Right.
It's as lawyers we become over-concerned of, well, is this discharging your FRAND commitment? Who cares whether you're discharging...
If I may say, I follow all of that. I'm just now seeking to focus on the precise point as to whether there's anything in the Travaux that supports your narrow interpretation of the ETSI obligation. And I've actually understood you just to say, no, there isn't.
I think I'd be right in saying no, because
that's fine.
It depends what you mean by the narrow. It's not that you can't...
Well, let me put to you what I mean by narrow. It's what I understood you to be submitting to us was the proper interpretation of Clause 6.1, that the only way the obligation, the FRAND obligation in Clause 6.1 can be satisfied is by the grant of a bilateral licence. Is there anything in the Travaux that supports that contention? There is nothing in the Travaux
that puts it in that way.
No. Okay.
What the Travaux seeks to do is to say this is what you must do, and the only thing that says this is what you must do is the bilateral.
That leaves me slightly confused as to whether you are or are not relying on the Travaux in support of the interpretations I've just put to you. If you're relying on it, you need to explain to us how, because at the moment I don't understand.
No.
What I'm seeking to say with the Travaux is that instead of heavily regulating what SEP holders had to do, they always had to be on FRAND. What the Travaux moves you to the position of is the SEP holders can do what they like with the licensing of their SEPs, but they must always be prepared to grant a bilateral licence on FRAND terms.
Well, can I repeat the question? Are you submitting to us that there is anything in the Travaux that supports your submission that the only way in which the FRAND obligation can be met is by grant of a bilateral?
I don't think I'll find anything specific to that.
All right, thank you.
Grateful, my Lord. My Lords, unless I can assist you further on ground one, I'll deal with ground two, and I'm going to assume against myself that your Lordships are satisfied that there's a serious issue to be tried and that the declaration is in principle arguable for a useful purpose. We say even on that basis, the majority in the Court of Appeal, paragraph 237 on page 295, would have rejected the appeal on the basis that it was not arguable that an evaluation of the Avanci 5G licence could be properly and fairly undertaken without all the SEP holders being joined or at least represented. Tesla Ground 2 necessarily seeks to appeal that decision, but it has little to say. The starting point, which as far as we can tell is not in dispute, is if the court opines upon the Avanci licence rate, it will affect the rights of SEP holders, all the SEP holders. That will be the case irrespective of whether the court considers the rate should go up, $50, down, $10, or even endorses $32 because it prohibits any change in the future. Now that brings us to this court's decision from last year in Nexus, which we've cited at paragraph 109 on page 146 of our written case. In Nexus, the court held that as a matter of procedural fairness, it was contrary to the most basic principle of procedural justice for the court to make an order which would alter someone's legal rights without giving them the opportunity to adduce evidence or make submissions. Now, in the normal course, that's achieved by making somebody a party to the proceedings. And in paragraphs 55 to 56 of Nexus, which is on 2427, on 2427, continues all the way through to paragraph 68, quoting Moscrop in the House of Lords for the long-standing statement of the proposition, which is on set out on 2430 at the top of the page at B. The courts have always recognised that persons interested are or may be indirectly prejudiced by a declaration made by the court in their absence, and that except in very special circumstances, those interested should be made parties, whether by representative orders or otherwise, before a declaration by its terms affecting their rights is made. And of course, it was Moscrop itself that the majority cited in paragraph 237 of the Court of Appeal. In our written case, we also refer at paragraph 110 to Darwall and Dartmoor.
Just before you leave Nexus, the obligation is in paragraph 56 to give the parties whose interests will be affected the opportunity to adduce evidence or make submissions. In other words, that might be fulfilled, it might be said against you, by giving a liberty to any other SEP holder who wanted to make submissions to be joined, to apply to be joined, rather than having to join them all at the outset.
My Lord, there's a number of difficulties with that. Firstly, it wasn't the answer in Nexus, and it wasn't the answer in Darwall. What this court didn't say in either is you must join, you give them the opportunity to join. In the present case, it causes real difficulties. My learned friend floated yesterday the possibility of letting this case go to trial and then allowing parties to come along and join whenever they felt like it. But the ones I really focus on are the 14, as set out in this, at the time in the Statement of Facts and Issues, the 14 SEP holders who have got no UK patents in the jurisdiction and aren't registered in the jurisdiction. They are faced with an absolute Hobson's choice.
There are 40 of them, are there?
14, my lord.
14,
and that was at the 1-4. And that was at the time of the Court of Appeal. I'm unable to give you the number as the platform has changed and the number of SEP holders have gone up. We've got 14 SEP holders, got no connection with the UK at all, have signed an American law contract, subject to New York law, relating at its best to its SEP obligations under French law, has not taken any patents in the United Kingdom, and that includes EP UKs, the European patents designating the UK, and are faced with the choice that their rights are going to be affected by proceedings in this country unless they choose to come here. And we say that's taking it to an extreme.
Can I just test this by reference to the conventional infringement situation? Mm-hmm. Suppose a particular SEP owner with UK patents sought to bring infringement proceedings against an implementer.
Yep.
And the implementer said, you haven't granted a FRAND license. And suppose there's an arguable, and the SEP owner said, oh yes, we have, it's in the platform license, and suppose issue 1, there's an arguable case that could be a FRAND way of doing it. So the SEP owner said, yes, we have, it's in the platform license, and that argument had to be determined to see whether they could get an infringement injunction. It wouldn't be necessary, would it, for the defence to join as a sort of putative defendant to a counterclaim every other SEP owner, but probably the court as a case management matter, if it could see that other SEP owners' rights might well be affected because it's a worldwide licence, would say, well, they have the liberty to come in if they want to. I'm just looking at it to see, to test it by what you might call a conventional example.
I understand the example that your lordship is giving, that it does face you with a very difficult problem, and there are ways to resolve it in terms of saying, well, they can voluntarily come or something of that nature. But what it really does is focus down on, well, whose rights are being relied upon here? Even on my learned friends' case.
Well, sorry, in my Lord's example, it would be the implementer relying on its rights in respect of that SEP.
Absolutely. That's
And as I understand the point of the example, the issue would have been very precisely joined between the SEP owner seeking to enforce and the implementer seeking to make use of the SEP. And the argument is whether there can be an infringement injunction if, and this is what would have to be argued out, there is not a FRAND license on offer.
And I'm accepting, of course, in that example, that the rights of SEP owners in the platform who had no UK patents could be affected in practice.
Perhaps I could just put what concerns me. I mean, if you take that example, it seems very difficult to think that the price of the implementer being able to run a defence which is properly open to them as a matter of their contractual entitlement vis-à-vis the SEP owner is that they have to join everyone else on a platform wherever they may be in the world.
I understand what my lords are putting to me. What I'm saying...
Well, are you saying that is the price? I'm trying to get a sense of what you're saying.
But the reason it's the problem, the reason it ends up, is that the rights being relied on, it does take you back to where you started, the rights being relied on aren't the rights of, or the contractual obligation that is owed from the SEP holder to the individual.
Yes,
If I may say so, I mean, I appreciate, and I by no means have put out of my mind all the important arguments you've run on the first issue, but if one proceeds down a line of reasoning where it is being said in these infringement proceedings, you can't enforce, the implementer says you can't enforce, you haven't made me a FRAND offer. The owner says, I have made you a FRAND offer, you can get a license off the platform. And then the implementer says, well, that is not a FRAND rate, it's too much. I accept, in principle, you can meet your ETSI obligation through through a platform license, but the rate is too much. That's a very precise issue that has then been joined between the parties, which the court would, in those circumstances, and assuming a certain amount along the way, would have to resolve. And that's the only way, and the court would have to resolve it in order to decide whether the implement has a good defence or not.
Yeah. And the problem I'm seeking to answer that is that the right to the platform licence, even if we assume at this stage that a right to the platform licence has arisen, isn't limited at that stage to the rights of the individual SEP holder who's chosen to bring the action. It is absolutely dependent at that stage on the other SEP holders. So you've got two choices to it. You either say the implementer has no right to enforce a portion of the SEP license, of the platform license at all, or the parties are bringing into issue all of the rights of all of the SEP holders, and then they do need to be a party to the action.
So I think then, as I'm now understanding you, you are saying that the price of the implementer being able to defend themselves in the situation that I've mentioned is that they have to join all the other SEP owners on the platform. That's what you say.
The implementer's primary response is this isn't a discharge of your FRAND obligation. But if you're
the SEP owner is saying yes, it is.
But if the SEP holder wants to say it is, and the court needs to entertain that, then both sides have got to recognise that the rights that are being pressed into service, which constitute the platform licence, is everybody's. and the court shouldn't be doing it, just like any of the other circumstances that are in the case. If you end up engaging genuine, valuable rights of other people and they get dragged into the proceedings because that's the only way the court can deal with them, you've got to have them as a party.
But I'm not for one moment suggesting that the court would prohibit other SEP owners from coming in if they wanted to. But the question is whether in that example you can't even get the defence off the ground without joining all the other SEP owners, including those with no place for registered address for service in the UK, and having to win a jurisdiction challenge to get them in. Or whether the court would simply say, well, of course we're not going to shut them out. They can come in if they want, and you must advertise that this situation is happening. And we will stay the proceedings for 3 or 4 months until everybody's decided whether to come and join the party or not.
Which we say that leaves these overseas entities with. Firstly, we do say they have to be present. Yeah. Be clear about that. We say they have to be present. We say that is the fundamental basic principle of procedural justice.
So to use my language, you are saying, well, the price of you being able to, you the implementer being able to run this defence is you have to join everyone.
They have to be.
That's what
they
you're
have
saying.
To be joined.
Yes.
And if they can't be joined, that is a problem with bringing those types of proceedings. And we say it actually stays.
Well, they haven't, sorry, in our example, the implementer hasn't brought those types of proceedings. It's an infringement claim. The implementer's just trying to defend themselves.
Whether it's the claimant takes the responsibility of bringing them into the proceedings or the implementer brings them into the proceedings, if they can't come into the proceedings, then their rights can't be adjudicated upon. And it shouldn't be left as a mere voluntary matter, particularly when you're talking about people who otherwise are outside of the jurisdiction. If they can't be compelled to come in, they need to be here, then that's the reason the court can't determine the claim.
That's so even in the IP field, one's seen frequently injunctions granted against persons unknown who may be operating particular activities or maybe internet service providers and so forth.
Yeah.
You would say they simply can't have injunctions granted against them or declarations made unless there is...
So the issue...
Unless a step is taken to actually bring them into proceedings.
The issue here is that when you're talking about making injunctions against persons unknown or something like that nature, it is a very special circumstance which starts with the premise that the parties cannot be identified and attempts cannot be made to serve them. And those types of actions have a liberty issue which enables a party to come back and say, I didn't even know this was going on. Whereas here we're talking about something very different. Everyone knows who the SEP holders are. Everyone knows their rights are going to be affected. But Tesla wants to have an action between it and Interdigital, maybe with me, maybe without, and affect the rights of people who are left having to decide whether to suddenly pitch up in the jurisdiction or potentially end up being bound or having their rights affected without them being here.
I think you contemplated the possibility that the onus might be on the SEP owner to bring in all the other parties if it wants to assert that the platform licence is a discharge of its ETSI obligation. And therefore the penalty, if he doesn't do so, presumably is he can't get an injunction for infringement.
Potentially so in an infringement action, but the difficulty is that it's very difficult unless there has been collective behaviour which is prohibited by competition law between the SEP holders. It's incredibly difficult for a SEP holder to say the platform as a whole is a discharge of everybody's FRAND obligations or my slither of it, because my slither of it doesn't exist.
No, it's all or nothing.
It's all or nothing. Yeah.
Right. And just so as I'm clear as to what the practical consequence of this would be, suppose whoever is trying to join in, one of the SEP holders, is met by them saying, I've got no connection with the UK, no particular interest in joining in, none of the gateways apply to me, and so they resist it. So not all the SEP owners have been brought in. Mm-hmm. Are you then, what does the court do in our infringement case? Does it grant the injunction, not grant the injunction?
If the SEP holder really wants the injunction at this stage, obviously it depends on the the legal process that the claimant takes in that case. What I would say the claimant clearly does is say, look, we're getting into real problems with the platform license. We can't get the right people assembled. I can discharge my Etsy obligation by offering you a FRAND license of my SEPs, is what it says in terms. It's a bilateral license. Here, Mr. Implementer, here is your bilateral offer. If you don't take that, then I want my injunction.
Why do you say that the onus is on the SEP owner rather than on the implementer to bring in everyone?
It depends on the individual action as to where it goes. If the SEP, if the implementer is saying there's nothing to stop the implementer setting out what a bilateral license would be and putting it up and saying, I'm prepared, this is the license I'm prepared to take to avoid an injunction.
Right.
I accept I've been found to infringe a patent. I would otherwise be subject to an injunction, but I've got my fundamental guarantee from Etsy. I'm entitled to a license, and I'm prepared to pay for a license, and I will undertake to pay for whatever license the court sets, that being a bilateral license between the SEP holder and the implementer.
Yes, I see.
And then the court can proceed. So it works both ways around.
Thank you, Mr. Nicholson. That may be a convenient moment. Now, I think that you are due to go this afternoon, allowing for the 15-minute early start till, well, in fact, you're at the end of your time now, aren't you?
Lord,
Sorry.
I've seriously underrun, and I've cut in on Miss Pickard's time.
Right.
We have 15 minutes after lunch, which
Well, you say that, but you started 15 minutes early.
we did. So we are very, very short on time. If
Well, I think we must allow Miss Pickard her 15 minutes
I think so.
I'd be very grateful.
after lunch, yes.
And I'll probably-
Very well. We'll resume at 2 o'clock.
Right.